All right, welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Bryce Brewer. Lonnie Roberts. Billy Otmo. James Godwin. Lauren Foley. Terry Johnson. Dakota Dole. Joseph Hazel. Jason Nichols. Christopher Richardson. Call number CR 23-225 for the record. It's been verified in custody of Smith County Jail. We'll recall that with Mr. at a later time. Claude Souls. Tyler Tadlock. Michael Zimmerman. Cause number CR 21-143, State versus Christina Maria Ross was set today for the plea. Defense filed a motion for continuance that was granted by the court, and Ms. Ross was ordered to be here tomorrow at 9 a.m. for her participation in the sentencing trial. Whether they're open for it. Daytona Blue. Tracy Jacobs. Jimmy Lynch. Larry Marshall. Caleb Wigington. All right, is there anyone present in the courtroom and your name's not been called? All right, do we have any attorneys that are ready? Bingham, you ready? Yes. All right, Mr. Otmo, if you'll come forward, please. This is cause number CR 22-235, State of Texas versus Billy Joe Otmo for a docket call. Go ahead, Mr.
Judge, I've talked to the state, and we'd really like to get this maybe pushed forward to another docket if we could. Mr. Otmo has a case in Henderson that I wasn't aware of. He's on probation in Henderson. I'm anticipating there could be some ramifications down there for what's happening here. He's got two new cases here, as the court's aware of, in addition to these. I haven't been retained on the case in Henderson or the new cases here. I have talked to Mrs. Curry, and I'll talk to the prosecutors on the case now about possibly trying to resolve all of them, but I'd like to have another month to do that to see if I'm going to be retained on those. I mean, obviously this is a pretrial diversion. We've waived jury. It would go in front of the judge, Your Honor. And so it's going to get resolved. I just want to see if I can get those two other ones here resolved. And if there is a problem in Henderson County, get that handled as well.
State.
State has no objection, Your Honor. I know we do have a couple of cases pending. I'm not sure the status of if those are ready to go to grand jury this time around. I expect if we have them, then they will be prepared. But state has no objection to resetting until we can try and resolve all of Mr. Otmo's business, at least with Van Zandt County.
All right, we'll grant Mr. Otmo an additional docket call hearing. Mr. Bingham, do you available March 26th?
I'm in trial in Austin and Travis County. Then, Judge, I'm sorry.
About April 16th.
Yes, sir.
All right, board says Mr. Otmo for additional docket call on April 16th at 9 a.m.
Appreciate it, Judge, for understanding. Thank you.
Yes, sir. State. So, Mr. Otmo, once you sign the notice of appearance and get the yellow copy, you're free to go. Have any other attorneys that are ready? Mr. Hawkins, you ready? Yes, please. On board. This is cause numbers CR 23-140, CR 23-141, State of Texas versus James Wesley Godwin. Set the docket call today. The court has met with counsel. Court's going to reset Mr. Godwin's case until March 28th at 9 a.m.
Thank you, Your Honor.
You're,
Your Honor, that conducts my business today, may I be excused?
yes, once he signs and gets the bill of copies ready to go. You're welcome.
Why did you just call one of my cases, please?
Sure. Who do you want to call?
Mr. Marshall.
Larry Wayne Marshall, CR 23-222. Mark, accept the redraw.
Your Honor, at this time, we're just going to abide by the court's pretrial order. I talked with the state, Mr. Hartwell and I. We're going to ask the court to move this over to docket call. And I don't believe if something comes up, and I don't think the state will object, that I need to file something. The state has indicated that it won't object if I need to file another.
March 26th.
That'll work, Your Honor.
All right, court says Mr. Marshall for docket call, March 26th at 9 a.m. Ross, you ready? Yes, Your Honor. Carrie Lorenzo Johnson, cause number CR 23-184. I think we're set for docket call. Go ahead, Mr. Ross.
Yes, Judge, thank you very much. And Judge, just for the record, it's cost, KOS.
I'm sorry. Any problem? I need to change. Oh, you're right. Just not looking at it very close. I'm seeing an R where I should see a K. I'm sorry about that, Mr. Cost. Go ahead.
And Judge, we're ready to go to trial in this case.
All right. So the defendant understands that the court is not going to entertain plea bargaining after today.
That's correct.
Once we set it for trial, we're going to have trial.
We're very happy with that, Judge.
Okay. All right. And so can I go ahead and have for the record what offer, if any, was made by the state that the defendant has rejected today?
Yes, Your Honor. State made an offer of 6 years deferred probation with restitution.
All right, we'll set Mr. Johnson for trial. We will begin that on March 18th. So, Mr. Cost, the way this works is the court has a rolling trial docket. The court has specially set cases. So Mr. Johnson will be required to be here on March 18th. His case will not go to trial on that date. He will simply appear, check in with the pretrial release officer, and sign a reset notice. And we'll continue to reset you on each rolling trial docket until this case is reaching trial. Once this case gets in the top 10, then you will be notified to be here as you would be liable for trial. So anyone outside the top 10, I don't require the attorneys to be here, but I do require the defendants to appear, check in, sign their reset notice, so that we know that they're staying in contact with the board rather than just setting them out for 6 or 7 months for.
I understand. And I'm glad to hear that, Judge. I have 3 other conflicts that day, so.
Yeah, so you're not gonna be required to be here. So Mr. Johnson, what you'll do is you'll check in when you come into the courthouse there on the 2nd floor. One of my staff members will be down there. They'll direct you on what to do, get you re-signed, get you a new notice, and then send you on your way. Okay. All right, so once you sign your notice, get the yellow copy free to go. Oh, actually, do we still need pretrial release conditions on this, or? Mr. West, do you have a condition?
I'm going to grab another package.
Okay, so Mr. Johnson, if you're not aware, the court is going to place you on conditions of pretrial release. I'm surprised I haven't already done that. So while you're on bond, waiting for trial in this case, you're going to have to comply with the court's pretrial release conditions, which require you to report drug tests, things of that nature. A violation of any of these conditions could result in your bail being revoked. Does that make sense? Ryan, your attorney can explain it to you more. Also, Mr. West behind you is our pretrial release officer. He'll go over all those with you. Get you a copy. Mr. White, are you ready on Mr. Blue? Daytona Blue, CR 23201. David, awesome.
Thank you, Judge.
Come on, Mr. Blue, right there. Right there, right there. Oh, that's fine. All right, court calls, cause number CR 23201, State versus Daytona, Wayne Blue. Blue is set for pretrial today. The council has indicated that there are no contested pretrial motions at this time. Court is going to set Mr. Blue for the docket call hearing on April 16th at 9 a.m. Well, All right, this is sanctions court hearing CR 16492. State of Texas versus Lonnie Joe Roberts. All right, Mr. Roberts, it looks like you have had a significant period of compliance. In and out of sanctions court. Looks like you complied with your last month's directions and orders, paying your probation fee, your collections fee. You're now paid in full on your collections. You completed all of your community service hours. You had 400. You got all of those done. So compliance is really appreciated. And so what I'm going to do today, Mr. Roberts, is since you've done well, is I'm going to release you from sanctions court. I'm not going to reset you today. You're still going to be on probation. Right? So just go continue to do what you're supposed to do. Pay your $65 for probation each month. Check in. Stay out of their hair. Stay out of my hair. Okay. You stay out of my hair. I'll stay out of your hair. Agree? Appreciate it. All right. You're good to go. Thank you, sir. Assuming that Mr. Manning and Mr. White, Nolan White need more time discussing with your client. So I'm gonna go ahead. It is 9:35. I'm gonna stand in recess until 10 a.m. At 10 a.m. I'm gonna check back with Mr. Manning, Mr. White, see if either of them are ready. If so, then we'll resume at 10 a.m. So you're welcome to sit in the courtroom. You're also free to mill about, go outside. So about 10 a.m. check back in. All right. So it's about 25 minutes. Court's in recess. All right, Mr. Manning, you ready on anyone?
Yes, Judge.
Who would you like to call first?
Mr. Nichols.
You may. Mr. Nichols, if you'll come forward, please. All right, this is cause number CR 21-87, State versus Jason Eric Nichols for docket call. Mr. Nichols, it looks like you want to enter into a plea agreement, so I'm going to ask that you raise your right hand so I can place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Lawyer. Your name is Jason Eric Nichols, correct? And Mr. Nichols, are you a United States citizen who writes and speaks English? Have you ever been diagnosed with any type of mental condition? Can you tell me what you've been diagnosed with? And are you currently on medication or undergoing treatment for those? Do you feel like you have a rational understanding of what's going on here today? Yes. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that's done with you? Yes. Feel like you've had enough time to talk with him about your case and that you understand everything in your plea agreement and all the paperwork that you've read over and signed? Yes. Mr. Manning, do you believe Mr. Nichols to be competent today?
Yes, Judge.
You've explained to him his rights regarding this case and also the advantages and disadvantages of the deferred communication plea.
I have, Judge.
You believe that he understands all of those and entering into this agreement intentionally, knowingly, voluntarily.
I do.
All right, Mr. Nichols, you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony does have a range of punishment of not less than 2 years or more than 10 years in prison and carries a possible fine not to exceed $10,000. I see the plea agreement you're asking the court to approve is that you would plead guilty to that crime in exchange for the state's recommendation that the court not convict you today, but rather consider the evidence and then defer a finding of guilt and place you on 7 years of community supervision, along with a $1,500 fine, $290 court cost, and $675 in reimbursement. Is that your understanding, Mr. Nichols? Yes. All right, Mr. Nichols, how do you plead to assault of a family or household member by impeding breath or circulation? Are you pleading guilty to that crime because you are in fact guilty of that crime? Has anyone threatened, forced, or pressured you to plead guilty? No. All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
Judge, stipulation of evidence has been previously entered. In this case, I would ask the court to take judicial notice of that. There's no objection to that stipulation of evidence as offered.
That's part of the pre-trial intervention, correct?
That is correct, Judge.
All right, court will take judicial notice of the stipulation of evidence in this cause. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Judge, we would just ask that the court accept this agreement. Mr. Nichols is a veteran. He was well represented by Mr. Casey Ashmore in his first go around. And we believe that being supervised here in Maine, that he should be able to complete this probation successfully and be able to contribute to society positively after this probation is gone.
My recollection is that Mr. Nichols was discharged from the veterans program in our sister county of Paul. Is that correct?
That is correct, Judge.
What were the issues that led to that, and have those been addressed? And are we going to be dealing with those same issues over here?
Yes, Judge. The scope of the issues we aren't totally aware of because it's a closed system in the Veterans Court. They don't keep records. But my understanding, and I believe the state would second this, is that he was violated due to drinking alcohol. He spent time in rehab, inpatient rehab down in Bonham, where he was there for 90 days in alcohol treatment down there. Since then, he's been sober. He's been doing well. He's working a steady job. He's taking care of his family. He's doing what he's supposed to. So I think we've turned that corner. The reason he was discharged is because the no tolerance program there in the Veterans Court. It's one strike, you're out. And so we're asking for him to have a second chance.
Thank you. Anything from the state?
I have nothing further to add, Your Honor. That was all the information that I was able to gather as well.
All right, Mr. Nichols, the court is going to extend you some grace today. Board's going to follow the agreement that you've reached with the state of Texas. I want to caution you though that, while it's not a no tolerance program here, on probation, the leash is getting much too short for you. You're one of the defendants that I recognize by name. Right, and so there's only a handful of those that stick with me, and you're one of those, so that's not good for you. So that means that if you violate any of your terms and conditions of community supervision, and I see a motion to revoke, I know you're faced by your name. Right, we've had many hearings before. You and Mr. Ashmore, the Veterans Program, we went round and round about that, and I gave you time after time, opportunity to try to prevent the situation that you're in here today. So I want you to know going forward that while I'm glad to hear that the report by Mr. Manning that despite you being discharged from that program, that you spent some time in your inpatient rehab, those are positive things. I want you to continue to grow on that. But if we start going the other way, I want you to understand I'm going to go the other way also. We on the same page? Yes. Okay. All right, based on the evidence before the court finds that there is sufficient evidence to convict Mr. Nichols of this offense. However, the court will follow the plea agreement in this case. Court hereby defers a finding of guilt on the third-degree felony offense of assault of a family or household member by impeding breath or circulation. Court places Mr. Nichols on 7 years deferred community supervision. Orders him to pay a $1,500 fine, $290 court costs, and $675 reimbursement fees. Hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence and have you come forward to be fingerprinted. And then meet with the probation officers and they'll think about it. Mr. Manning, who else are you ready on?
The judge ready on Dakota Dole.
Mr. Dole, please. Court calls number CR 23-147, 2021-539, State versus Dakota Blade Dole. I think that we're pretrial and ag assault. It's MTA on the misdemeanor assault. Go ahead, Mr.
That's correct, Judge. We are ready to proceed about how we have no pretrial issues at this point in time. We are in negotiation with the state and providing some information the state is considering, but we've not received an offer at this point in time. We request that we get offered before our 7-4 docket call.
All right, then court finding there are no contested pretrial motion. Court will set Mr. Dole for docket call on the ag assault. Remind me, are you available on March 26th?
Yes, Judge, I believe I am. Let me come and check that.
That's a Tuesday though. You would need the 28th.
Judge, either the 26th or the 28th would work. I prefer the 28th.
All right, if that's the day for docket call, go ahead, I'll place you on that one.
Thank you, Judge.
March 28th at 9.
And I've been unable to meet with him to go over his discovery. If we could have one more pretrial setting, just so we can get all the discovery together and go over that, I'd appreciate that.
Any objection from the state?
No objection, Your Honor.
Court will set Mr. Dole for pretrial on March 28th. 9 a.m. Okay, so I show that you're delinquent on your pre-trial release fees to $90. Can you make a payment today?
Saturday, tomorrow, Friday.
Well, which one is it? I wanna know, can you make a payment today?
No, sir, not today.
How much can you pay tomorrow or Friday? Or tomorrow is Friday?
$90.
$90, so you pay in full tomorrow?
Yes.
And so I'm gonna need you in there, their office opens at 7, I believe, on Fridays, is that right? 8. It's gonna open at 8, close at 12, so I need you to, I need you to appear between 8 and 12, pay that $90. All right? Real straight.
Judge ready on Mr. Richardson. That was the one in Smith County.
CR 23-225, State versus Christopher Michael Richardson. Mr. Richardson is still verified in custody in Smith County. Do you have any information on that, Mr. Man?
I do not, other than he is in Smith County. I have not spoken to him or his attorney over there.
State, do you have any, have you been in consultation with the Smith County DA's office to find out any more information?
Your Honor, I haven't, my computer's locked up, but I can, try and find some information for the court.
My court's gonna reset Mr. Richardson for status, custody on March 28th. State defense can both work, respective channels to find out what we need to know on Mr. Richardson.
Yes, Judge.
Next.
Mr. Souls.
Law Raymond Souls, CR 21-6. Mr. Souls. You're on motion to revoke, Mr. Main, go ahead.
Yes, Judge. I had the opportunity to speak to the probation department, and particular the officer for this case. They are wanting to do based on some of the documentation we provided about Mr. Souls' medical situation. They are wanting to reset him until after April to do a hair follicle test, drug test. One of the allegations is drug use, and they're requesting to test him after that point in time. I didn't know if the court would permit something that far out, but that's where our conversations have resulted in at this point is they're wanting one more test to determine where he is.
And it's, there's an issue with his medical condition.
Yes, Judge. He is diagnosed with stage 4 cancer. And so that medical diagnosis is going to provide a defense or mitigation for several of the allegations. The only one withstanding would be the drug use. And Mr. Souls has informed me that he's been sober since the last test, and so the probation department would like to verify that.
So you want me to set it in May
Yes, Judge.
for the probation? We'll set it on May 30th, the evidentiary document. Next,
Judge, ready on Mr. Tadlock?
Tyler Tedlock. Cause number CR 2376, CR 23191, CR 23112, CR 23193. Here's that we are on docket call for all of us. Go ahead.
Judge, and just to kind of give you a rundown, we have just arrived on docket call for 191 through 193. I've been in negotiations with the state, and as of this morning, we have a tentative agreement on those cases. We would request to be set for a plea on those. Those cases would result in him going into custody on the day of plea, so we request to be set at 1:30, and we would request that that be on the March 28th.
Six. Only concern I've got.
Yes, Judge.
The only concern I've got with 28th is that's an evidentiary day, so we'll be having inmates brought over here that day. Might not get to be reporting at the jail.
Absolutely, Judge. That's not a problem at all. We will set him for the 26th at 9 a.m. or at 1:30.
Oh, you said it'd be 1:30, right?
Yes, Judge.
Right. Court sets Mr. Tadlock for the plea before the court March 26th at 1:30.
May he be excused.
Yes, you're excused. Who else ready?
Judge, I believe my final one this morning is Mr. Zimmerman.
Michael Cody Zimmerman, CR 23-121. Zimmerman set for Dr. Call.
Judge, this is also a fairly recent placement on docket call. Mr. Zimmerman we have requested an offer on his case, but have not received one. We request one final docket call so we can see if we can get an offer on the state.
State anticipate making an offer on this case.
Yes, Your Honor. I think this is one that just kind of fell through the cracks. So now that it's on our radar, we be taking a look at it and extending an offer.
All right, court will set Mr. Zimmerman for final docket call March 28th. I don't show that Mr. Zimmerman is on conditions of pretrial release. Have you met with Mr. West? You already met with him? Got him signed up? Okay, thanks.
Judge, may he be excused.
Yes, Mr. Zimmerman, you're excused.
I believe that concludes my business. May I be excused.
Yes, thank you, Mr. Michael. Sir. Tracy Jacobs. All right, this is call number CR 23-100. Jacobs, if you'll raise your right hand, let's take your oath. Jacobs, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? There we go. All right, Ms. Jacobs, your name is Tracy Lane Jacobs, is that correct? And Ms. Jacobs, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? Been diagnosed with?
Yes, the bipolar depression and anxiety.
Are you on medication or undergoing treatment for those? You feel like you have a rational understanding of what's going on? You gotta let me finish. So you gotta know what the question is. Two, my court reporter has to write down what you have to say, okay? I know you're just trying to be helpful with them. Do you feel like you have a rational understanding of what's going on? We're proceeding against you here today.
Yes,
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation?
yes,
Like we've got enough time to talk with Mr. White about your case, and you understand everything, the plea agreement and all the paperwork that you've read. Mr. White, do you believe Ms. Jacobs to be competent? If so, have you explained to her the rights regarding this case and also the advantages and disadvantages for adjudication?
Your Honor, I have explained the advantages, disadvantages of a deferred adjudication. So if it violates any term or condition, or will hold a hearing, or determines that she did in fact violate her community supervision by ponderance of the evidence, the court would have the entire range of punishment at its disposal, which is up to 2 years of state jail. $1,000. Your Honor, I've had absolutely no problems communicating my client on this matter. As understood.
Thank you. All right, Ms. Jacobs, you are charged by indictment with a state jail felony offense of theft of property between $2,500 up to $30,000. The range of punishment for that type of offense is, if convicted and sentenced, would be not less than 6 months in the state jail prison and not more than 2 years, and a possible fine of up to $10,000. I see the plea agreement in your case is that the court, upon your plea of guilt, would defer upon your guilt. That means not convict you of this offense, but rather would place you on community supervision for 2 years. And during that period of community supervision, you'd be ordered to pay restitution in the amount of $5,000. And actually, so are you paying that today?
Your Honor, that will be paid today to the DA's office through my out.
Thank you, Mr. White. So as part of the plea agreement, you would pay $5,000, a little over $5,000 in restitution today. You would have court costs and a $35 reimbursement fee. And during that period of community supervision, you're going to have terms and conditions you must comply with. And I'm sure Mr. White's already gone over this with you, but if you violate any of those terms and conditions, I'll vote, bring you back to court. They could request a hearing, and if during that hearing they present evidence that you violated any of your conditions, the court could do several things, including adjudicating your guilt, convicting you of this felony offense, making you convicted. Court could revoke your community supervision. Court would assess punishment anywhere 6 months all the way up to the maximum 2. You know all that is. All right, then let me ask you, Ms. Jacobs, at this time, how do you plead to theft of property between $500 up to $30,000? Are you pleading guilty to this crime because you are guilty of committing this crime? Does anyone threaten, force, or pressure you to plead guilty?
No.
All right, then the court will accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted. The court takes judicial notice of the defendant's judicial.
No, Your Honor, thank you.
Defense?
No, sir.
All right, court's going to review the stipulation. All right, based on the evidence presented, the court finds that there is sufficient evidence to convict Ms. Jacobs of this offense. Will follow the plea agreement between the parties. The court hereby defers the finding of guilt. 2 years community supervision. Orders her to pay restitution in the amount of $5,029 today. The court also orders her to pay court costs of $290, reimbursement fees of $35. Ms. Jacobs, you hereby remanded to the sheriff so he can carry out the terms and conditions. And you come forward and be finger. After that, you can meet with probation officers and they'll tell you about what's next. Caleb Wigington. All right, Mr. Wigington, if you'll raise your right hand, sir, I'll place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Your name is Caleb Allen Wigington. Is that correct? Mr. Wigington, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes, sir, just ADHD.
Are you currently on any medication for that?
No, sir.
You feel like despite your ADHD, you're able to have a rational understanding of what's going on in this proceeding against you?
Yes.
In this case, you have an attorney, Mr. Nolan White. Are you pleased with Mr. White and his representation?
Yes.
Do you feel like you've had enough time to talk with him about your case to the point that you understand all of your documents that are part of your plea?
Yes.
Anything that you feel like you do not understand or that the court or your attorney can address?
No.
Mr. White, do you believe that Mr. Wigington is competent to enter into this pretrial intervention contract?
I do, Your Honor.
And you've explained to him his rights as they pertain to the terms of this contract?
I have, Your Honor, and we've gone over the fact that he's waiving his right to a jury trial as well as stipulating the evidence. So essentially, and I've explained this to Mr. Wigington, if we end up back in here, the issue is not one of guilt or innocence, but will be one of punishment. And he also understands that we expect completion, that he does have a limited right to expunction.
And you believe he's competent in entering into this agreement, potentially knowingly, voluntarily?
Absolutely.
So, Mr. Wigington, I do want to follow up on something that is very important that Mr. White has noted, and that's your waiver of jury trial. You understand that you have the right to have your case presented to a jury of your peers for them to decide whether or not there's sufficient evidence to find you guilty. And you understand that if you waive your right to that jury trial today, that right may not be restored to you in the future, meaning that if you do this agreement and you violate it, you may not get to come back in and say, hey, now I want a jury trial. You understand that although Mr. White has signed this form indicating that he agrees with you waiving it, he can't waive your right. I can't waive your right. The state of Texas can't waive your right. The only one that can waive their right is you. Yes. And you're waiving your right to a jury trial today because that is the decision that you've made under these circumstances.
Yes.
All right, and Mr. Wigington, the charge for which you have been indicted is a possession of a controlled substance, penalty group 2, between 1 gram and 4 grams. And I believe that that is a 3rd-degree felony. Is that correct, Mr. White? GT2. All right, a 3rd-degree felony carries a range of punishment. If you were to violate this agreement, come back before the court, and if the court were to find you guilty, then the range of punishment that you could be subjected to would be a minimum 2 years in prison up to a maximum 10 years in prison and a possible fine not to exceed $10,000. You understand that full range of punishment?
Yes, sir.
And in this agreement, it appears that you're going to be in this program for a period of 2 years. You understand that?
Yes, sir.
And that as part of this agreement, there's certain things that you're admitting to, and also that you are allowing the state of Texas to admit into evidence later should you violate.
Yes,
sir. Mr. Wigington, how old are you?
26.
26. That's your first criminal offense?
Yes, sir. This count.
And this is a pretty large caliber, wouldn't you agree?
Yes, sir.
It's pretty serious.
Yes.
And we're talking about potentially up to 10 years of your life in prison. So is this something that you're going to take serious?
Oh, yes.
All right, then. Court is going to approve the placement of Mr. Wigington into the pretrial intervention contract program for a period of 2 years on the 3rd-degree felony offense of possession of a controlled substance. All right, Mr. Wigington, I want to have you come forward to sign the paperwork with the probation officers, and they're going to tell you about the next step.
And Your Honor, may I approach?
You may. Yes. Yes. Sorry. All right, Mr. Lynch. All right, this is cause number CR 23-187, State of Texas versus Jimmy Walter Lynch. Mr. Lynch, if you raise your right hand on the patient oath, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Is your name Jimmy Walter Lynch? And Mr. Lynch, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
And what have you been diagnosed with? And are you currently on medication and under treatment for that?
Yes.
Do you feel like, despite your mental health diagnosis, that you have a rational understanding of what's going on here today?
Yes.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
Yes.
Mr. White, do you believe Mr. Lynch to be competent? And if so, have you explained to him his rights regarding this case and also the advantages and disadvantages of a deferred adjudication plea?
Your Honor, I believe that Mr. Lynch is mentally competent, understands the proceedings, the opinion against him. Your Honor, I've also explained to Mr. Lynch the advantages, disadvantages of entering such plea.
Thank you, Mr. White. Mr. Lynch, you are charged by indictment with a second-degree felony offense of assault of a peace officer. That range of punishment of 2 to 20 years of prison, but I see that there's an agreement in your case wherein the state's recommending that your charge be reduced to that of a Class A misdemeanor assault causes bodily injury, where you would not be convicted, but you would be placed on deferred community supervision for a period of 2 years. And you would also pay a $1,000 fine plus court costs and reimbursement fees. The range of punishment for a Class A misdemeanor offense of assault causes bodily injury is confinement in the county jail for up to a maximum of 365 days. And a fine, if imposed, cannot exceed $4,000. Is that your understanding of the plea agreement? Yes. All right, then, Mr. Lynch, how do you plead to the Class A misdemeanor assault causes bodily injury? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the statement?
No, Your Honor.
Is there victim compliance, victim notifications, the victim supportive of this plea?
Yes, Your Honor. Victim in the case is Constable Tommy Monk. He indicated that he was supportive of the plea going forward as a listener.
Thank you. Anything further?
Only that I know that the state, if they consider, not only Mr. Monk, but they consider some of the intended circumstances as well as coming to this, and that's why we came to this.
Thank you, Mr. White. All right, court's going to review the evidence. All right, court, finding that there is sufficient evidence to convict Mr. Lynch of this offense, the court will follow the plea agreement today. Court hereby defers the finding of guilt on the lesser included offense, Class A assault causes bodily injury. Board will place Mr. Lynch on 2 years community supervision, or he will pay a $1,000 fine, $270 court costs, and $25 in reimbursement. Mr. Lynch, you're hereby remanded to the custody of the probation department, so we can carry out the terms and conditions of employment. Yeah, you going forward, you fingerprinted it. No, that's all I got to do, so. Thank you, Mr. Wright. See you separately.
No.
Berg. Come on up. This says cause numbers CR 23-203 and CR 24-3, State of Texas versus Rice, Andrew Brewer for arraignment. Mr. Brewer, I believe that you have requested for appointed attorney, is that correct? Yes. The court has reviewed your information, finds that you are indigent. So the court's going to appoint you an attorney. The attorney that we were going to appoint today, you've already met with Mr. Manning. Yes, sir. And he indicated to me that there was potential conflict. Yes. Wherein that he represents some of the other individuals who have also been charged with the same type of offense or the same offense that you've been charged with. So what I'm going to do, Mr. Brewer, is I'm going to reset you today, and I'm going to appoint another attorney. And my coordinator will do that today or tomorrow, and she will contact you with the information for the attorney. Yes, sir. Okay. Well, you have an email, you have a cell number and an email. So what I'm going to want you to do then. All right, Mr. Brewer, so this is what's going to happen. My coordinator is going to come in. She's going to make that appointment. She'll contact you with that, give you the information from the attorney. And so once the attorney receives the appointment, they'll need time to talk with the state. But in the meantime, you'll also talk with the attorney, and we'll see you back on March 26th at 9 a.m. Okay, any questions?
No, sir.
Okay, all right, there you go. Oh, I'm sorry. Have you met with a pretrial release officer, Mr. West? Did he come and?
I'm supposed to ask me to meet him.
Okay, excellent. Yeah, meet with him outside. So you were arrested in this case and you posted a bond, right, to get out of jail. So you're going to have conditions of pretrial release, which means that You're gonna have to appear, drug test, you're gonna have to pay money towards your court appointed attorney fee. If you violate any of those, the court could take that violation and revoke your bail, and put you back in jail. That's what those conditions are gonna be about. So make sure that you understand those and you ask Mr. West if you have any questions. Okay. Thank you. You're welcome. This, is Mr. Ashmore and,
I believe maybe in the jury room, Your Honor.
all right, court's gonna stand in recess for just a few moments so we can get the plea papers prepared for this moment.